You're sitting in a sterile conference room. Fluorescent lights hum overhead. Across the table, a lawyer in a tailored suit slides a single sheet of paper toward you. It's not a confession, it's not a threat, it's just a question. And the lawyer says quietly, "Whatever you do, don't try to answer this alone." You look down. The question seems simple, almost innocent. But that's the trap. Because in that moment, you have no idea that the next words out of your mouth could hand the opposing side the keys to destroy your case. So let me ask you directly, have you ever been questioned by police, by an insurance adjuster, by HR, or even by your own attorney, and felt the urge to just explain yourself, to be helpful, to clear things up? Pause this for a second and think. Then drop a comment. What's the one thing you've always believed you should say if you were accused of something? I'll wait. But here's the truth most people learn too late. There is one specific answer, one seemingly logical, honest, almost reflexive response that career prosecutors and veteran defense lawyers say destroys more cases than almost any other mistake. And today, we're going to walk through exactly what that answer is, why it's so dangerous, and how even innocent people get swallowed by it. Let's rewind to a real deposition from a civil case in Texas a few years ago. A woman named Carol was sued after a minor car accident. The other driver claimed severe injuries. Carol felt terrible. She was honest. During her deposition, the plaintiff's attorney asked her, "Before the accident, did you ever have any problems with your brakes?" Carol hesitated. Then she said, "Not really. I mean, sometimes they felt a little soft, but I never thought much of it." That was it. 14 words. The opposing counsel didn't ask about speeding or distraction or liability, just the brakes. And Carol volunteered that tiny, seemingly harmless detail. At trial, the plaintiff's lawyer played that clip 3 times. He argued that Carol knew her brakes were faulty, drove anyway, and caused the crash. The jury awarded nearly double the initial settlement offer. Carol's own insurance company later told her if she had simply answered, "I don't understand the question," or "Can you rephrase that?" or said nothing at all, the entire brake argument would have been impossible to prove. But she gave them the ammunition herself. So what is this lethal answer? It's not a swear word, it's not a lie. It's the well-intentioned, honest, and completely devastating phrase, "I think." Or its cousins, in my opinion, probably, maybe I should have, to be honest, and the single most dangerous of all. I don't remember, but I assume. Why? Because once you speculate, you leave the ground of fact and enter the swamp of inference. And in court, inferences can be twisted, reshaped, and used against you even when you're telling the truth. Let me give you a criminal example, because this is where lives truly change overnight. A young man named Marcus was questioned by detectives about a theft at his workplace. He was innocent. He knew he was innocent. The detective said, "Look, we just need to clear this up. No one's accusing you, but between 2 and 3 p.m., you were near the supply room, right?" Marcus nodded. Then the detective asked, "Is there any chance you might have accidentally taken the laptop thinking it was yours?" Marcus, eager to cooperate, said, I guess it's possible. I don't remember exactly, but I wouldn't do that on purpose." That single sentence, "I guess it's possible," was written into the police report as a verbal admission of potential guilt. The prosecutor later told the jury, the defendant himself said it was possible he took the laptop. Marcus's lawyer nearly lost her mind, because in the law, possible is not probable. But to a jury, it sounds like doubt, like even the defendant isn't sure. The case was eventually dismissed due to lack of evidence, but only after Marcus spent 3 months under pretrial monitoring, lost his job, and drained his savings. All because he tried to be helpful. Here's the legal principle that every viewer needs to tattoo onto their memory. Anything you say that is speculative, uncertain, or based on assumption can be admitted as a statement against interest. Under the federal rules of evidence, and nearly every state's rules, a party's own words, even if they're hypothetical, even if they start with, "I think," can be used as an admission. You don't have to say, "I did it." You just have to say something that a jury could reasonably interpret as suggesting responsibility, fault, or inconsistency. And once that genie is out of the bottle, no lawyer, no matter how skilled, can put it back. Think about the last time you were in a tense conversation. Maybe with a boss, a landlord, or a neighbor. You wanted to de-escalate. So you said, look, maybe I overreacted. Or, I suppose I could have been more careful. In everyday life, that's called being reasonable. In a legal setting, it's called Exhibit A. I want you to pause again. Have you ever said something like that during a dispute, only to regret it later? Comment below. Seriously, I read these. Because the pattern is so common that lawyers have a name for it: the helpful client syndrome. It's the instinct to fill silence, to explain, to justify. And it's the same instinct that opposing counsel prays you'll follow. Now, let's talk about the most dangerous version of this answer. The version that appears in nearly every police interrogation video you've ever seen on YouTube. The detective leans in, friendly, almost paternal. He says, "Look, I'm not saying you did anything wrong, but if someone else did this, what do you think should happen to them?" That's a trick. Then he asks, "Do you think it's possible you touched the doorknob without realizing it?" And the suspect, exhausted, confused, says, "I don't know. Maybe." Boom. That maybe is now in the transcript. The detective will later testify. The suspect admitted it was possible he left fingerprints. That is not a confession, but it sounds like one. And jurors are human. They hear maybe, and their brain translates it to probably. Real case from Florida, 2018. A woman was accused of writing bad checks. She had a legitimate banking error. But during an interview with a fraud investigator, she said, "I guess it's possible I didn't check my balance before writing that check." The investigator wrote, "Subject admitted she failed to verify funds." That single sentence shifted the entire case from civil misunderstanding to potential criminal negligence. The charges were eventually dropped, but not before she paid $15,000 in legal fees. Her attorney later told a local news reporter, if she had simply said, "I don't recall," or "I need to review documents before answering," she would have saved herself a year of hell. So what's the alternative? What should you say instead? This is where legal experts agree across the political and ideological spectrum. From public defenders to corporate litigators, the consensus answer is the same. You say, "I don't understand the question. Can you rephrase it?" Or you say, "I'd like to speak with my attorney before answering." Or, if you're in a deposition or a police interview, you say, "I'm not going to speculate." And then you stop talking. That's it. 3 sentences. No explanation, no justification, no, "but you see, what really happened was," because every word after that is a thread that opposing counsel can pull. Now, I can already hear some of you thinking, "But I'm innocent. Why wouldn't I just tell the truth?" That's the most dangerous question of all, because the truth is not a straight line. The truth is a web of perceptions, memories, and details. And when you try to walk someone through that web without a lawyer, you will make mistakes. You will say, "I think," instead of "I know." You will say "probably" when you mean "possibly." You will guess a time, a date, a distance, and then, when the evidence shows you were off by 5 minutes, the opposing side will argue you're lying. Not mistaken, lying. And that's how innocent people lose. Consider the famous case of the Central Park Five. Before we get into the politics, focus on the interrogation tapes. 5 teenagers questioned for hours. They gave inconsistent answers. They said, "I think," and "maybe," and "I don't remember, but probably." Those speculative statements were used to convict them. Years later, DNA proved their innocence. But the speculative answers, the "I think we were there" and "maybe we touched him," those words had already done their damage. The lesson is brutal but clear. Your memory is not a recording device, it's a reconstruction. And when you speculate, you hand a jury the blueprint of your own uncertainty. So here's the practical advice that every defense lawyer wishes they could broadcast on national television. If you are ever in a legal situation, whether it's a traffic stop, a workplace investigation, an insurance claim, or a formal deposition, you must train yourself to recognize the speculation trap. When someone asks you a question that begins with, "Could it be possible?" or "Is there any chance?" or "Do you think maybe?" you do not answer. You say, "I'm not comfortable speculating." Or you say nothing at all. Silence is not an admission. Silence is a shield. In America, you have a Fifth Amendment right against self-incrimination, But even outside criminal law, in civil cases, you have the right to say, I don't know, and stop. Not, I don't know, but maybe, just, I don't know. Let me give you a script. Practice this. Say it out loud right now. I don't have enough information to answer that. That's it. That is the most powerful sentence you can ever utter in a legal setting. It's honest, it's humble, and it gives opposing counsel nothing to grab onto. Compare that to, I think I probably would have noticed if something was wrong. See the difference? The first is a wall. The second is a door. Now, I want to be clear. I'm not telling you to lie. I'm not telling you to obstruct justice. I'm telling you that the legal system does not reward helpfulness. It rewards precision. And precision requires time, documents, and a lawyer who can translate your story into legally safe testimony. If you are ever in a deposition or an interview, your job is not to be nice. Your job is to be accurate. And you cannot be accurate when you're speculating. Let's wrap this up with a story that still haunts me. An elderly man in Ohio was sued by a neighbor over a property line dispute. The man had survey maps showing he was right. But during a mediation, the neighbor's lawyer asked, "Isn't it possible that your fence is a few feet over the line?" The old man, tired, frustrated, said, "I suppose anything's possible." That phrase, "anything's possible," was read to the jury as if he had admitted error. He lost the case. He lost his property. He lost his peace. All because of 4 words. So here's my final question to you, and I genuinely want you to answer in the comments. What's one thing you've said in a moment of stress that you wish you could take back? Because understanding that feeling, that sinking realization that words cannot be unspoken, is the first step toward protecting yourself. The law is not a conversation among friends. It's a battlefield of words, and the only winning move is to know when not to play. If you take nothing else from this video, remember this. The answer that destroys your case is not a lie. It's not a confession. It's an honest, well-meaning, dangerous word. Maybe. So the next time someone asks you to speculate, do something that feels unnatural. Stop, breathe, and say, I don't speculate. Then close your mouth. Your future self will thank you. Thanks for watching. If you've ever been through something like this, share your story below. It might help someone else avoid the same trap. And as always, stay safe, stay informed, and never let politeness override your rights.